Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another edition of the Colorado Trial Lawyer Connection podcast. Super excited for this episode to talk about a very unique helicopter case handled by Nicole Quintana and Kylie Schmidt from Ogborn, Mihm. And for those of you who have been following, Ogborn Mihm has really developed a reputation of handling these complex aircraft cases, and this one sort of falls right within that realm. So I'm very excited factually to talk about a different type of case with a different type of injury than we're used to seeing all the time. So with that long-winded introduction, welcome to the show, Nicole and Kylie.
Thanks for having us, Keith.
Oh, thank you for coming on. And one of the things I do like to do before we kind of dig into this particular case is just to give the listeners a little bit of an idea of your background. So Nicole, let's start with you. Did you always know that you wanted to be a trial lawyer?
Yes and no. It was a split between being a teacher or being a trial lawyer. I actually, after graduating, went to paralegal school. So I have been with whatever variation of Ogborn Mihm for 20 plus years now. And I started as a paralegal, went back to law school, and loved the trial work. So stuck with it.
You know, I don't know if you listened, but we had a few episodes ago where someone else was a paralegal with Glenn Fair's office, 20-something years, went to law school, first trial, complete home run out of the park. And so my question to you is, do you recommend if someone, say, getting out of college, they think maybe I want to be a lawyer, would you highly recommend that they pursue the paralegal route as kind of a dipping your toe in the pond type test?
If you're on the fence, absolutely. I mean, we all know what kind of investment going back to law school is. And if you're not certain, or if you're just not certain about the area that you want to go into, trial work is a whole different animal, as we all know. And I think coming into a trial firm, seeing what that looks like, getting to get into the courtroom, made me super passionate, knowing that that's exactly what I wanted to do. And then I got into law school and joined the trial team so that I could start immediately, trying cases, as they say. And then similarly, I tried my first case with this firm, I want to say within 6 weeks.
Oh my gosh.
Getting my official license to practice. So.
Holy cow. So when you were in law school, you knew trial was the path. So you were on trial team and from there you just kind of hit the ground running.
Yes. Yep.
Wow, that's fantastic. And so how long have you been a practicing attorney with Ogborn Mihm? Because you look like you're 25 years old. So I'm just trying to, the math here, I just is not adding up. I'm like, this first trial must have been last year.
I have been a lawyer for 16. I guess this is my 16th year. And then I was a paralegal for 4 years before that.
Okay.
Right? Roughly, maybe 5 years.
Wow. So you have been with a wonderful firm for a lifetime. I mean, that is a real rarity. So congratulations to you on that. That's amazing.
Yep. I'm fortunate. Very fortunate.
Yeah. Kylie, what about you? Did you always know you wanted to do trial work?
No, I changed my major about 5 or 6 times in college. And it wasn't until the very end that I interned for a judge at a criminal court at the end of college where I thought, gosh, this is probably the right path for me. And then during law school, I ended up going at night and working during the day. I started as a nanny. And then my second year of law school, I started some miscellaneous jobs and then landed at a firm where I clerked and had the opportunity to see what the trial work was, very much like Nicole, see the inner workings, help with trial exhibits during trial. And after doing trial exhibits for my very first trial that ended up being a plaintiff's verdict, it was a game changer for me. I was overcome with emotion. I was so overwhelmed by the experience. And at that point, I was hooked.
Wow. So you got to And that was not Ogborn Mihm that you were able to witness the inner workings?
No, it was with, at the time, Leventhal and Puga. I had
Oh,
a chance to
fantastic.
work there and cut my teeth on medical malpractice cases and seeing some extremely high level trial work very early on.
Yeah, I mean, just one of the top tier medical malpractice firms in the country. So you get to see the inner workings, all the blood, sweat, and tears that go into that, and then a plaintiff's verdict on those most difficult cases. And the story I'm telling myself is you were sold off and running, and then landed at Ogborn Mihm once you got out of school. Did I get that right?
No, I actually was with Leventhal and Puga for several years, and
Okay.
then did some plaintiff's employment work. After that, I ended up working with Jason Wysoki for a while, doing general civil litigation, but still with the plaintiff's bent to it, and ultimately landed at Ogborn Mihm in the summer of 2021, where I've been ever since.
Great. So going on, I guess, 4+ years now at Ogborn Mihm. And where are you physically located now? Are you in the Denver area or have you branched out?
I have branched out. I actually moved to Jackson, Wyoming. My husband grew up there and we decided to relocate there. So currently I'm in my home office, but here in Jackson, Wyoming with Ogborn Mihm's Jackson office and branching out to practice in Wyoming as well as Colorado.
Fantastic. So obviously you're licensed in Wyoming.
Yes.
And
yes,
no caps in Wyoming. So that seems like a good place to practice if possible. So it probably didn't take much arm twisting to get Ogborn Mihm to open up an office in Jackson, I'm guessing.
Well, a lot of legwork, a lot of kind of getting things rolling, so to speak, and making my presence known. But it's been a wonderful way to just kind of on-ramp into some Wyoming cases while also collaborating with the rest of the team back at Ogborn Mihm HQ in Denver.
I love it. Love it. Well, we are here to talk about this amazing factual and legal verdict and victory that y'all had. So, Kylie, why don't you tell us a little bit about the facts of this case and what happened?
Sure. So, my client, David Jepson, about 50 years old, had been a paramedic for many years and then got into doing flight paramedic work. And he lived in the Western Slope and ended up doing a lot of work both on helicopters and fixed wing aircrafts. It kind of depends on how critically ill the patient is, depending on which, aircraft they flew on. And the aircrafts that he flew on were owned and operated and maintained by a company called Air Methods. He was not employed by Air Methods. He was employed by a healthcare group out there. And unfortunately, one fall day in 2019, there was a loss of cabin pressure while he was tending to a patient with a colleague of his in a fixed wing aircraft shortly after it took off. And he experienced a pop noise in his ears. And him and his colleague discovered that they were hypoxic or had low oxygen levels. And it was a pretty severe change in pressure, especially he experienced this really horrible pain and felt like he had been punched in his head and was diagnosed about a day later with something called barotrauma, which is damage to those tissues in the ear when the outer ear and the inner ear's pressure can't equalize quick enough when the pressure changes are too fast.
So we're talking like an inner ear injury, sort of like when our eardrums pop, but like 10 times worse is what I'm hearing?
Yeah, so there's the outer ear, inner ear, and middle ear. But this barotrauma, we understood to impact both the middle ear and the inner ear because that pressure wasn't changed. This is also an injury you see in scuba divers when they don't have that pressure that's equalizing. Some folks may have experienced issues with equalizing that pressure on certain air flights before too, but this one was where there was a loss of cabin pressure. There was an outflow valve on the aircraft that wasn't functioning appropriately that caused this pressure change that shouldn't have happened.
So before we dig into sort of the specifics of what happened and why, Who did you sue and what was the verdict? I always like to lead with that so people sort of understand, and then we can kind of work our way backwards.
Sure. So we sued the defendant Air Methods Corporation, which is the company that operated and maintained the aircrafts that
Okay.
Mr. Jepson flew on as a paramedic. And the verdict was actually split into amounts for a first incident and a second incident. The one I just described to you before was incident number one. That verdict was $378,000. And then the
Okay.
second incident that happened during the course of litigation was a $17,000 verdict.
So the same manufacturing defect or whatever it was that caused this, which we'll talk about in a second, that happened again and hurt your client a second time during the course of litigation?
After we filed suit, there was another pressurization loss that my client experienced while he was still working for this company. Again, it was a fixed wing aircraft, completely different aircraft, but nonetheless, a second loss of cabin pressure that was attributable to issues with maintenance. So the second one, I guess to sum it up, it impacted him very much emotionally, where the first one happened and he did a lot of hard work to recover from that and get back to work. And then when the second one happened, he really lost faith in the safety of the company and ended up leaving his job as a flight paramedic after that.
How did you figure out what went wrong and caused your client's injuries?
That was a very expert-heavy analysis. As much as I'd love to say that I dug into the maintenance records of the aircraft and figured it out myself, I had the assistance of a wonderful accident reconstructionist engineer expert group that specializes in aviation to help figure that out and discern it. There was also documentation that we were able to obtain during discovery that set forth the analysis of what had happened.
So did the client come to your firm sort of early on thinking it was a work comp claim, and then you all dug into it to realize, wait, this is a third party claim? I guess what I'm wondering in my mind is, I imagine firms like mine or other smaller firms, they get a call like this and they're thinking, whoa, first of all, this is a crazy complex case. Secondly, this seems like maybe this happens all the time. I don't know that somebody's negligent or not. And third, it could be a work comp case. So how did you guys sort of work through all of those issues to figure out, wait a minute, there's a third party negligence claim here that's valid, and end up with a great result?
So by the time I got involved, the comp process, at least from incident number one, had concluded. And that was actually one of the really challenging pieces of this case, was how the work comp process played out. And the weird thing here is, with hearing loss and with tinnitus in the comp realm, the impairment rating under Colorado law, with the more archaic AMA guides that the comp docs are required to follow, you can only get an impairment rating for tinnitus if there is pre-existing hearing loss in the normal speech frequencies. And so if there's high frequency hearing loss or low frequency hearing loss that's pre-existing or exists with this tinnitus or tinnitus, which I've learned you can pronounce it both ways.
I was always wondering that. So I've already learned something amazing and new, because I'm glad to hear that I was doing it okay.
I did ask my expert about that. So
Perfect.
Good to know. So it was very strange with comp. And strangely here, the comp doctor originally said this is a 1% impairment rating because Mr. Jepson's tinnitus was so significant and impacted his life so much. But the doctor later found out, oh, I messed up my comp evaluation because I was comparing the wrong hearing tests. I was using his post-incident hearing test with hearing loss as the pre-incident one. And as I said before, if there's pre-incident hearing loss, that allows you to rate impairment for tinnitus. And when he found that out and redid the impairment rating, it was actually a 0% impairment rating. And
Great.
that's something we had to deal with during trial with the strangeness of the AMA guides and also this bizarre impairment situation with the comp doc.
So when you all were hired, the comp case was essentially finished at that point?
When I became involved, it was over. And so I have those documents and I looked and I got, gosh, this is going to be an interesting one to deal with.
And so is it because of your experience and your firm's experience handling aviation cases that you knew to look at the maintenance issue on what was causing the rapid depressurization?
Yes. It was digging into those records and knowing that, yes, we've got to bring on a really high quality expert here to dive into this and help us figure it out, and also assist us with explaining to a jury in as simple a way as possible about how this system works, how it malfunctioned, and how it could have been prevented.
And I think, Keith, if I can jump in.
Yeah, please.
In many of these circumstances, it is that the operator of the aircraft is separate and apart from the folks who are flying on, in a helicopter or fixed wing, who are providing the paramedic or the flight nurse services. So while that may not be true across the board, it's certainly somewhere to start where you're looking to see who is the actual employer and then who's responsible for the pilots and the maintenance of the aircraft.
Is there a heightened standard of care, duty of care, because it's, I'm almost thinking of like the commercial carrier context. Do they have a higher standard of care?
There is a jury instruction that does talk about it, but since we ended up going to trial where negligence was ultimately admitted, that wasn't something we had to tackle.
Okay.
But I didn't get to argue that with jury instructions because we did not have to go there.
So what you mentioned, there was an admission of liability, I think, late in the game. Can you talk to us a little bit about pre-trial settlement negotiations? So, I mean, I'm hearing that if there's a maintenance issue and there's a rapid depressurization, your client's hurt, seems like a case should settle. Why didn't this case settle?
Well, I think a lot of it had to do with Mr. Jepson's recreational activities. And
do tell.
He really interesting. He was a paramedic during the time of the Columbine shooting. And after that happened, he developed an interest in learning more about explosives, tactical trainings, how he can protect himself as a paramedic if he gets in these really dicey situations. And after that, over the course of many years, he did a lot of tactical rifle shooting courses. He did explosives handlers courses. He hunted for fun. And so that past use of guns and explosives and being around that, I believe that is why this ended up getting tried, because the causation and the damages being only emotional distress, tinnitus, and hearing loss with that long history of his recreational activities, as well as just noise exposure in ambulances and such with work, made it a tough one, I think, for the defendants to resolve before we tried it.
I should have asked you this when you were talking about the verdict, but was the verdict impairment or was there only non-economic damages? And did I hear you just say that you waived all economics, I guess, because of the work comp situation?
We did future economics for the first incident.
Okay.
Mr. Jepson ended up benefiting greatly from hearing aids with sound therapy, which is a way he can use his phone and program different sounds to play into his ear to help distract his brain from the buzzing and the ringing and the annoyance of the tinnitus, which just was life-changing for him. And so our future damages included those hearing aids and audiology appointments to help, get new hearing aids over the course of his life. We did not claim any past economic losses. And then the remainder was non-economic, and impairment. And for that second incident, after, emotionally, it really impacted him, having gone through one depressurization incident and then another. We just claimed for that incident non-economic loss.
Got it. So, Nicole, how did you and Kylie split up the trial, and how did you guys decide? Not, this is the end result, this is who did what, but how did you guys go about deciding who did what during the trial?
Sure. Well, I will start with, this was absolutely Kylie's baby. She took this case on, and because it was continued multiple times, had been deep in the case and the documents, called 2-3 years. I forget exactly how long it was before I came into it. And it was really, I guess it started because she was going to be out of town during 702 motions. And so I had stepped in to help with briefing. And then when it came time to say, hey, this is going to trial, then she and I wound up dividing up the labor, with her handling the damages and the medical side of things, and me stepping in to handle the liability. So I got the easy end of it when they ultimately admitted liability, though that was a tough road to hoe in and of itself. So that was how we determined. She essentially took the laboring oar on the hard part of it, and then I took the expert part, which wound up being easier.
How close to trial did they admit liability?
Well, so
it's a saga.
It is a saga. So I want to say it was a year, right, Kylie? I think when they initially admitted liability, and then we wound up getting continued because Air Methods, I am not a bankruptcy lawyer, but essentially filed for sort of a reorganizational type of bankruptcy. And so it stayed our action for a period of time. They came out of that. And then we couldn't get a trial set for almost another year, I think, basically. But their initial admission, from our perspective, was not, in fact, an admission of fault. They weren't admitting anything specifically. They basically just said it was our fault. So we had made specific allegations of, you failed to properly maintain, you failed to properly operate, you failed.
Yes.
And they refused to actually own up to any of those individual allegations in an attempt to cut us off from talking about any of that with the jury. And so Kylie, again, certainly took the laboring oar on making arguments to the judge that this isn't a sufficient admission of liability. And then the other aspect of what they tried to do was they didn't like Colorado jury instructions. Our lawyers were from Texas, and absolutely good adversaries, worthy adversaries, but didn't like our instructions and the way that our negligence instruction is broken out.
Okay.
So they would not admit negligence, but they admitted fault. And we said, well, we have an instruction that uses the word negligence, and you either have to own that or you don't.
Yeah.
And if you don't, then we get to put on all of the facts as to how it was that you were negligent in this case. So that was, I will say, a year-long battle, though it sort of started. Then we went into the stay. And then there were more motions and more hearings as we led up to trial, trying to get them to own something specific so that we knew what we were going to say and not say come trial time.
And as I'm sitting here, I still don't understand what happened. So what went wrong? Who messed up that caused this plane, I guess, and another plane to have the same problem later, to have this rapid depressurization?
So two separate but kind of related issues. On the first, an aircraft has something called an environmental control system, which is the process of the air coming in and flowing out, right? And it maintains pressure at a level that is acceptable to the ears, where you can still equalize your ears, right? Keeps it comfortable inside of the cabin.
Okay.
In this circumstance, there was an outflow valve, as Kylie had talked about, that was dirty. So the plane was actually kept outside when it was on the ground. And the suspicion is essentially that, there's wind and air and dirt getting into these parts. And it caused this outflow valve to stick. And so the environmental control system wasn't circulating air the way that it was supposed to, which impacted its ability to properly stabilize the inside of that cabin. So that was overall, and that's maybe a simplified version, but that's essentially what happened. And so the plane lost pressure mid-flight.
Okay.
And that's what caused the pop in the ears.
And so how high was the plane flying when it lost pressure?
It was about 18,500 feet.
Okay. And that's is that above sea level, or is that 18,500 feet above Denver, which is, a mile up?
That's above sea level. Yep.
Okay. And so when it lost, was the pressure supposed to have been set at approximately what the pressure is in the Denver metro area?
So it is set higher for sure. And that was one of their defenses is, look, jury, you live in Colorado, you know about 14ers. People go up that high all the time. This isn't that big of a deal. It's not that substantial of a depressurization to have caused this particular problem. So yes, the pilot, when you get into the plane, is supposed to set that cabin pressure at a certain level. And I'm forgetting in this circumstance what it was. I want to say
3,000 to 4,000, I think was.
Oh, so lower than Denver.
Yes.
Okay.
Yes. Which was an interesting aspect of you're almost depressurizing below where you even start.
And this is an off topic, but is that how come every time I get in a commercial plane, I fall asleep like 10 minutes after it takes off? Is that the answer?
I don't know the answer to that.
Okay, I'm going to go with yes. So, all right. So you've got, what I'm hearing is, but this was rapid. So this is a pressurization from 3,000 or 4,000 to 18,000. Is that what happened when it failed? It went all the way up to 18,000 feet pressure?
Again, that was hotly contested in this case. We use the term depressurization because anytime you go from one pressurization to another pressurization, that is a depressurization. Their stance was this was not a depressurization. This was a loss of some pressure. It was not significant and it was not rapid in particular. And the issue with the rapidity was it really enough to cause the damage to the ear that Kylie explained and ultimately the tinnitus? So part of what we were combating was this was a depressurization. This was rapid, and it was significant enough of a depressurization to actually cause the damage as we had alleged.
Did anyone else on the plane experience the same current phenomenon?
That's a good question. So there was a flight nurse on the aircraft as well, who also sought treatment afterward for similar issues. But all of that was kept out of the case. That's not true. I guess some of it came in because they opened the door at one point, I think, to it. And then the patient on the plane had oxygen on and they were better able to manage that. The additional question was whether the pilot didn't suffer any damage to the ear, there was a question of whether the pilot was actually hypoxic at the time, which was also disputed in the case. So
how come, I don't know, maybe this is a dumb question, but were you surprised by the admission of negligence? Because just hearing those sort of basic facts here sounds like, a fun case for trial. They've got arguments, you've got arguments. Any idea what was the smoking gun that caused them? Kylie, I don't know if this was your baby from the get-go. Did it surprise you that they admitted negligence? And if not, why not?
I think it surprised me that they admitted it so late. I thought it was pretty clear on the first incident that there was a problem here. There were several incidents leading up to this showing that there was an issue with the pressurization system. The airbags had deployed just days before this, and those got put back in, and no workup was done. And so there were red flags leading up to it. And I thought that was pretty powerful history there that should have led to an earlier admission. It didn't. And fortunately, though, we were able to get some of that evidence in the trial, even though we did have this negligence admission because of door opening that happened during the testimony of the pilot during the first incident.
Can we just stop for a minute and ponder that we're talking about door openings and it's a plane case where depressurization, just to,
Yes.
maybe that's just where my mind goes.
You
All
also
right,
have a plane behind you and you're
I know. I was going to say something. I was going to say something about that before, but all right. So first of all, dumb question. Do airplanes have EDRs or of course they have black boxes, in the event that they crash or whatnot, but you were able to obtain sort of other failure data from the plane. And if so, can you let our listeners know what kind of information is available to someone investigating plane cases like this?
I think it really depends on the company, what data they have, but they are mandated by the FAA to have maintenance records. So those maintenance records from before and the sign-offs on whether or not the aircraft is quote unquote airworthy is something that's required to be maintained. So any work that's done, parts that are replaced, and that certification of airworthiness, that's something that's going to be there in every aircraft case. In terms of the additional data that's available, it depends if there is, a recording of everything that happened during the flight. We did not have here internal readings of cabin pressure. It was actually an analog gauge in this aircraft for the first incident. So there wasn't any kind of readout or data in that respect. Sometimes you can see on like a website like FlightAware what the altitude of the aircraft is at any given time during the flight. And there are different flight path files that you can download into, say, something like Google Earth that will show you the time and the altitude of the aircraft and also its speed.
Okay.
So that's just the sampling of the data in addition to, figuring out if a particular company has internal documents, emails, and specific kind of reporting that might shed light on what happened or a particular aircraft.
Now, either Kylie or Nicole, did either of you have specific expertise in the types of issues that came up in this case related to pressurization, records, et cetera? And if not, or even if you had some expertise in that, how important is having the right expert lead you down this discovery journey in a case like this? And I'll just throw this to either one of you, Nicole, Kylie, and who wants to take that one?
I had no background in this at all. I watched a lot of YouTube videos and flight simulator videos and such to try to get a handle on what does it even look like in this aircraft and how is it configured and how does one operate it. And I did that before going into the depositions to try to get the background, but certainly quality expert helped just such a great deal.
Yeah, now, I echo that. I knew nothing about fixed wing, right? The last one that we worked on was a helicopter case. And in that, oddly, I was on the flip side of it where I was primarily handling damages. And so I was less involved on the liability side of things. I think having the right expert is magical. Mm-hmm. I think having, particularly in these cases, an experienced expert is so integral. Who was familiar, oddly, was actually personally familiar with defense counsel, but being as familiar with the process of testifying in court, understanding the basics of evidentiary rulings and what can't come in, what could come in, understanding the opening the door issue and then what that could do to the testimony. And here in particular, so because they hadn't admitted liability, the expert reports covered the gamut.
Got it. Yep.
And then when they admitted liability, it significantly limited what the court was going to allow our experts to testify to. And so I had gone through, well, this opinion is still relevant, this is still relevant, this is still relevant, to the jury's overall understanding of whether this was rapid and whether it was a significant enough depressurization. And so having an expert that could also go through and understand the difference between, I'm not really talking to liability, I'm talking to causation here, was extremely important, I think, in this case.
Mechanism of injury is what I'm hearing you say. And so how did the judge come down on that before we talk about what opened the door? But pre-trial, were you allowed to talk about the mechanism of injury opinions?
Pre-trial, everything was
I'm saying
at
once
trial. Yeah, at trial, it really was limited to what are the aspects that a jury needs to hear to understand whether it was significant enough of a depressurization to cause the injury.
Okay.
That was essentially what we were limited to.
So you kind of won you were allowed to talk about mechanism of injury opinions. So I get that that's sort of the playing field as you go into trial. No discussion about liability beyond that. What happened to open the door that allowed you to go further?
I'm trying to remember exactly how this played out. So I think early on, we did not, because these were analog gauges and we didn't have a black box that was giving us all of the readings. It was hard to provide an opinion specifically on what that depressurization was, right?
Okay.
And how rapid it necessarily was. What our expert could say was that there was a test. So after they grounded the plane, there was a test done afterward where you stay on the ground, they test their gauges and figure out whether the pressurization system is working.
Okay.
They did that and it failed after the fact. Because it failed, that actually gave our experts some sense of what that depressurization actually looked like. When they admitted liability, the judge said, you're not bringing in any of the prior issues with the plane. You're not allowed to get into the post-flight checks that they did. You can talk strictly about what happened while they were on that plane.
Wow.
And then our expert, and Kylie, you might have to hop in here. I asked him a question and he sort of alluded to, well, there are ways. Oh, no, they opened the door, actually. They, on cross-examination, said something to the effect of, well, you don't actually know how bad the depressurization was. And he said, actually, I do.
Wow.
And he and I had talked about this. So, of course, defense counsel moved on, didn't ask him any more questions about it. I got off on redirect. First question out of my mouth is, you mentioned that there are actually ways you can tell how bad the depressurization was. They objected on the basis of their motions in limine and the admission of liability. And I said, they opened the door. They asked him. They got the testimony from him. So now the jury gets to hear how he can tell and what that actually meant. So,
and so I'm picturing in my mind the sidebar that was occurring, and you were in front of Judge Figa, correct?
Yes.
And how was Judge Figa in trial?
I thought he was amazing. I thought he was a fantastic judge. You know, not every ruling went our way by any stretch of the imagination. I thought he was extremely smart. He was reasoned. He did a fantastic job from my perspective of keeping a proper record.
Okay.
So not just ruling, but then also backing up his ruling with an explanation, with case law. I think he was even-handed with both sides. You know, when there were things that any counsel would do that he wasn't necessarily pleased with, he would express that displeasure, but did it equally to both sides. So I thought that he managed the case extremely well, ruled quickly both pre and during trial, and just was a great judge to be in front of, honestly.
It's so great to hear. Every time I'm able to ask people that question, we get a similar response. It just, makes me so happy because the independent and fair judiciary is just so critical to what we do and is constantly under attack. So that just is music to my ears, no pun intended. So Kylie, talk to us a little bit about tinnitus and how you went about explaining the damages to a jury to achieve a really phenomenal. I mean, we're talking close to $400,000, if not more than $400,000 for ringing in the ears. Help us understand how you taught the jury about the condition to warrant such a result.
Again, I had the help of a great tinnitus expert that helped me with this. But my number one goal in this is how can I simplify everything to make it as easy as possible to understand and wait to see what the defense does to rebut it before I preempt everything and make things more complicated. And ultimately, it was one, explaining here's the ear, here's how sound passes through the ear and what happens. Here is what happened in this circumstance, which is how that change in pressure damages the tissues in the ear. As simple as that. If you cannot equalize your ear pressure from the outside and the inside appropriately, it causes damage because of expanding or vacuums, depending on the pressure dynamics. And that damages the ear tissues. And when the ear tissues are damaged, you can have hearing loss and you can have tinnitus. And one thing I was careful to address in my expert report, and also I hope in the expert testimony, is you can have tinnitus without hearing loss. You can have hearing loss without tinnitus, and you can have both. And tinnitus can come from barotrauma independent of hearing loss. And so we talked about it in that way where, hey, just links in the chain. Here's how the ear works. When it's damaged, you can have tinnitus, or you can have hearing loss, or you can have both. And yes, it was the expert's opinion that the tinnitus was a cause of, or the barotrauma caused the tinnitus and the barotrauma caused the hearing loss. So I kind of decoupled it to help the jury understand you don't need to have one or the other from this type of mechanism of injury, to try to make it simpler.
It sounds like Nicole was probably smiling ear to ear in the inside, hearing you teach the jury how the ear works and how this injury was caused. Was that something that was intentional on your part? And I've heard other people talk about doing like a teaching section in opening. Did you guys address that in opening? And then when you had your expert on, was it truly like school's in session?
Totally was. And, Nicole is so organized. It was such a joy to try a case with her that she had her opening prepped and ready and gave it to me before trial. And we kind of tweaked some of the facts and we tweaked the teaching components and where to expand and where to contract, just to make sure it wasn't too much information at once. Mm-hmm. And then when we had our medical expert come in to tie it all together, I had him step down and I had him be a teacher and talk about the ear diagram and establish that for the jury in as basic of a way as possible, to give them that background and hopefully the context they needed to say, yeah, this really is all tied together.
Did the pre-existing, I don't even want to say pre-existing issues, but the hunting, the explosions, how did you deal with those landmines?
Yeah, we were fortunate enough to do 2 focus groups on this case before we tried it. And my primary goal in those focus groups is how the heck are people going to address the hunting and the explosives? Is it going to be something that they say, oh, okay, this is all bogus? Or they look at it and say, oh, I see why this case is going to trial. And we tried we kind of did an A/B test in these
Okay.
focus groups. The first one, we did our position without any of the background about hunting or explosives or history, and then did defendant's position, and then did plaintiff's position to see how people reacted.
Okay.
And there was a pretty intense reaction when defendant's case came on and they learned about the explosives and the gun use and all of that, where we're like, interesting. Then the next time we did it the other way, where we did plaintiff's case, where we just got it all out there.
Yep.
And then we did defendant's case. And the reaction on that was very different.
Wow.
It kind of took the wind out of the sails and helped them focus in on what really mattered rather than a big gotcha once defendants came up. And so that informed directly the opening statement that Nicole did. We put pictures up from these courses that our Mr. Jepson did to be able to say, here's his life. Here's what he does for fun. Here's a photo of it. Here's what they're probably going to say. And we got in front of it, and I think it lent our side of the case a lot of credibility.
So I have a follow-up question about that because I find it fascinating, the case framing aspect of that. Do you both believe that it was a case specific to your case, that in this particular case, it made sense to get all that bad stuff out up front? Or do you believe that 9 times out of 10, the majority of time, when you've got a plaintiff with something that's bad, you got to just get it out and get ahead of it? Or was it case specific to this case, if that question was not a terrible question?
I am the latter. I think you always have to get it out. Well, 9 times out of 10, you've got to get it out. I think this one was without a doubt.
Mm.
You know, there were, and I don't even know that I can rattle all of them off. In this particular case, it was all of the explosives and the gun training. But there were, 6 other things that they were trying to point to. And it was as minor as he used a Q-tip, right?
Wow.
And so we knew that they were going to go after absolutely everything. And I think in the opening statement, we made a very deliberate choice to say, you're going to hear 1, 2, 3, 4, 5, 6, 7. And then they got up in their opening. And sure enough, you're going to hear jury 1, 2, 3, 4, 5, 6, 7. And it was a great mirroring of, here's everything they're going to tell you. And you know what? We're not afraid of this because none of this matters, jury. And then they got up, said that exact thing. And then that was what they hammered on through the entire trial. And, they were right to do so. I am not faulting them for it. But I think that, to Kylie's point, it lended us a lot of credibility to put it out on the table first. And then to have them hammer on it, I think at some point the jury said to themselves, this is too much, right? It just sounds like excuses at this point as opposed to being legitimate defenses.
The anything but defense. My question is, how did the jury instructions look with respect to those 6, some prior, some subsequent, I'm guessing? I mean, what did was there like a comparative fault line for the jurors, or was it just subsequent, intervening, prior? Can somebody help me with the jury instructions on this case?
Well, I'll start, just because the admission of negligence and the admission of liability issue is a pet issue I've had for many years. And it is always my view, if they do not admit negligence and they do not admit precisely the negligent acts in a more complex case that were negligent, then there is no admission at all. And that's a lot of what we fought along the way. In addition to that, if you are admitting negligence, you cannot have a comparative fault defense. You cannot have an assumption of the risk defense, because you are admitting that you were negligent. And because of that, I do think through the work we did at the pretrial conference, we were able to narrow down and bring up to the judge and defense, hey, these are the defenses that are no longer legitimate because you have finally admitted negligence in some capacity. And so I'd encourage other practitioners to look very closely at the affirmative defenses that exist when there is either an admission of liability or negligence, that one element, to say, what can you eradicate? And then I'll let Nicole jump in on the final instructions, but this is something I wanted to say.
Well, please educate me, because I'm going to fall on the ignorance sword here and say, I didn't know that if you admit negligence, that takes away comparative negligence and subsequent intervening, like causation arguments. This is why I love doing this podcast. I learned so much new stuff. Nicole or Kylie, please educate me.
Yeah, and Kylie might have to jump in on this because I'm trying to remember. It's in the notes to the instruction itself, and if it is an unqualified admission, and that's essentially what it came down to, is what are you actually admitting to, and thus what instructions are you entitled to? I'm trying to remember whether we actually won on that issue. I don't think we did. We made the argument the entire way along. And the court, so I guess the other aspect of it was that they were relying on all of these explosives trainings courses, guns trainings courses that all happen pre-incident.
Okay.
But they were addressing it like it was a pre-existing condition, right?
Okay.
So this is an activity he participates in, but there's no condition to it. And so we were making the argument, you don't get a pre-existing condition instruction because there was no pre-existing condition. You are arguing that maybe there's a superseding or intervening event that happened afterward, but there was no causal chain. There's a break and then you've got other stuff happening. So we were fighting this sort of awkward argument with them that didn't necessarily make sense. I understand why they were making it, but didn't really make sense when you looked at the facts of our particular case. And so it wound up boiling down to a failure to mitigate at the end of the day. And that was where they hung their hat on this idea that, he went back to an explosives course after the fact. And why was he doing that? And did that exacerbate, make worse, whatever it may be? So,
and was it not a pre-existing condition because your client was asymptomatic? In other words, there was no evidence that he had hearing loss, tinnitus, any of these issues before this incident?
We were fortunate in this case because he was a flight paramedic. That he had to undergo annual hearing exams. So you might not get that with a lot of clients where you have all of this evidence prior to, and I forget which range it is. He had a minor amount of hearing loss before this in an upper range, but wasn't having any tinnitus, didn't have any other symptoms of it. It wasn't impacting his daily life. And so
normal for age, right? Normal for age.
That's right.
Yeah. We had questionnaires from every single hearing test that he underwent at work saying, do you have ringing in the ears? Do you have buzzing in the ears? No. So they couldn't dispute that the onset didn't occur until after his last questionnaire. But he did undergo an explosives course between that last hearing test and questionnaire and the incident itself. So we were lucky. He had purchased this very high-end double hearing protection right before that course. And so one of our trial exhibits was his email receipt from purchasing that shortly before the course he did in between the last hearing test and the first incident.
Wow. I have so many questions, but we're getting near the end of our time. And I really wanted to ask you about your damage model and your damage ask. So either Kylie or Nicole, how much did you ask for from the jury, and how did you go about determining what that right number was?
Yeah, I borrowed a lot from what Kevin Chaney and Tim Galuzzi have done in the last several years, where you do a separate model for impairment from non-economic damages. And given the bizarre issue we had here with the workers' compensation impairment rating.
Yeah.
What I chose to do was, again, value of the human body and a percentage of that for the tinnitus and the impact that has that physical impairment has on his life. But because of that 1% impairment rating and then the 0% impairment rating, what I ultimately did is put up on a slide in closing, I think it was 4 or 5 different percentages, where I argued, hey, this is the value of his body now. If you have 0.5%, 1%, 2%, 3%, and I put those figures up there, and I said to the jury, you aren't bound by the AMA guides edition that the work comp doctor is. You're allowed to say that, yes, this has impacted your life, and here are some percentages that'll allow you to choose what you think is fair. Because our client did testify during his testimony what the jury thinks is fair for impairment during his cross. And so I tied that in, laid out that model, and then they came in, I think it was around 193,000 for physical impairment from the first incident, which was more than that. I think it was around 2% based upon the value of the human body that I had proposed to them. And then for the non-economic loss, I did a per diem calculation. Okay. I think I divided it out in between before he got hearing aids and after, because it really was a life-changing thing for him. So I decreased the per diem ask after he got these hearing aids, because that sound therapy had such a positive impact on his ability to cope with the tinnitus and go about his daily life. And so that's how I did it there. And then for the second incident, it was just non-economic loss. So I modeled again a per diem on here's where he was really struggling emotionally until he left the job, and did a model there. So,
wow, fabulous. And were there any serious pretrial settlement negotiations?
We had a failed mediation, and there was a mediator's proposal of $450,000. At the time, there was a punitive damages motion pending that we lost. And then the defendants responded or provided an offer of $100,000, decreasing $10,000 a week until trial after the mediation.
Okay.
We did a stat offer of $375 after the failed mediation.
Wow.
And then during trial, we were asked to give an offer, and I believe it was around $685, and they responded with a very low bracket that just didn't even seem worth responding to at that point. So that's kind of the summary of the negotiations, but our stat offers certainly helped in getting 100% of our bill of costs awarded.
Yeah, I guess I know we're kind of getting at the end here, but sometimes I hear people say that plaintiff stat offers serve no purpose, but you just gave a perfect example of how they can help tremendously when it comes to case costs. So do you routinely in your practice, both Nicole and Kylie, see the value in filing plaintiff stat offers?
I don't often do them.
Okay.
The reason it made sense in this case is because we had very expensive aviation experts and damages that, in our view, realistically, we weren't going to go in and do a 7-figure ask at trial, given everything that was on the table.
Got it.
And because of that, we knew those expert costs were going to get extremely high if we had to try this case, and it was likely a case we'd end up trying. And even though it only gives you a bit of a leg up in, normally costs are reasonable and necessary, but if you do the stat offer, its actual costs, it gives you a leg up when arguing your bill of costs. Although I'm not sure how often judges are dealing with that situation when there is a plaintiff's verdict. A little leg up, I wouldn't do it in every case. I think this was a unique one where it did make sense and help.
I love that. Wow, this has been such a eye-opening and wonderful, such a unique case factually. Nicole, what's sort of one thing that our listeners could take away from what you experienced in this case? Do you have like one sort of tidbit of takeaway knowledge?
I know we didn't talk as much about this. I think for me, I expected the defense to go down one road, and it shifted for me during trial to that failure to mitigate, which was not what I was expecting them to do. And I think being able to pivot quickly, knowing our case and knowing the facts of the case and being able to be prepared for arguing jury instructions based on that helped us. And I think we got the evidence out that we needed regardless to combat that. But I think you got to be ready for anything at trial because things can change on a dime depending on ruling.
Kylie, what about you? Do you have a sort of a takeaway for our listeners?
I really enjoyed representing our client, Mr. Jepson, and having a client that trusted us to go in and try this case and understood what would happen if there was a loss and still trusting us to do that. That was a really defining moment for me in my career, feeling that no matter what happened, I had a really good relationship with the client to trust me to go and try a case, and win or lose, I knew we'd end up, ending the representation in a positive way. And that, choosing your clients and developing relationships with your clients to build that trust and, taking your profession seriously and the work that we do and making sure the client's there and informed and understands the good and the bad and the ugly that happens along the way. I think it's reiterated that me spending the time to do that is worth it. It's worth it.
Wow. Well, first of all, congratulations to you both on an amazing, factually complicated, righteous verdict. And thank you so much for coming on and sharing your wisdom with everyone. So on behalf of myself and all of our listeners, thank you, Nicole. Thank you, Kylie. And please join us again next time on the Colorado Trial Lawyer Connection podcast, where we will continue to ask successful Colorado trial lawyers what worked and how they were able to achieve justice for their clients. Thank you both, and thank you all for listening. Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.